Jury. I'm like, we do this all the time, how come it's not working? Please be seated. The jury has returned to the courtroom. We think it was just a bad computer, and we have everything fixed by switching out a computer now. So hopefully everything works. As I indicated before, Dr. Robbins, you remain under oath. Go ahead with cross-examination, Mr. Lassay.
Okay. Dr. Robbins, I believe where we left off was, well, first of all, I just want to confirm. I asked you, I think, at the outset that it's true that while you reviewed a lot of records, you did not review a lot of information from professional sources regarding Mr. Cayer that predates June 7th of 2016. Is that correct?
It is.
You had information from family members, information from Mr. Cayer himself, but really nothing from mental health professionals.
That's fair.
And then I think we started to...
Oh, sorry. Thank you.
Started to talk about the fact that there were several different professionals that have evaluated Mr. Cayer throughout the course of this case, correct?
Correct.
The procedural history is such that there were multiple competency evaluations and, in fact, 2 different stays at Mendota Mental Health, correct?
That is correct.
And I think you testified to some of this earlier already on direct, but it is true that the different mental health professionals that evaluated Mr. Cayer had different opinions at different points in time about, first of all, his mental health condition or diagnosis. Is that correct?
It is correct.
Ultimately, I think at the end, your diagnosis ended up being largely consistent with some of the more recent diagnoses in this case. Is that correct?
It is.
So particularly those who evaluated him in 2019 and then I think into early 2020, there was quite a bit of consistency regarding the diagnosis. Is that correct?
That is correct.
That wasn't always the case, though, correct? There were other doctors, particularly at the outset, that came to different conclusions regarding his condition.
I agree.
They did, in fact, observe fairly consistently, however, similar attributes or characteristics in Mr. Cayer throughout the 4 years. Is that fair to say?
I think that is fair to say.
So, I think that just potentially demonstrates some of the complexity of practicing psychiatry or mental health diagnoses in general. Isn't that fair?
Well, I think it often takes time for a diagnosis to become clear, particularly with psychotic disorders.
So you think the passage of time is one of the reasons why there's been some consistency?
I do.
Isn't it also fair to say, though, that mental health, unlike perhaps math, 2 + 2 always equals 4, and everyone's going to agree on that, but you would potentially have mental health professionals who would view the same symptoms and come to a different conclusion regarding that the ultimate diagnosis.
That's possible, although the DSM, there is some overlap between diagnoses, but I think it really is the DSM that Mr. Cotton was talking about earlier really makes an attempt to make diagnoses clear and based on very specific symptoms. That's really the purpose of the DSM. Try to avoid some of what you're talking about.
But you also mentioned that there is this idea of overlap between conditions. So there are a number of symptoms, perhaps delusions, for example, that are associated not just with what you've diagnosed him with, but are associated with other conditions as well, correct?
That is correct.
And some of the difficulties of Mr. Cayer's personality play into that as well. And I think consistently the medical professionals that have evaluated him have diagnosed him sort of with both, having those psychotic characteristics, but also having the personality disorder.
Correct.
And there is some overlap between how one would view those characteristics of the psychosis are also present in the personality disorder. Is that correct?
Yes, some, but that there's less in terms of the psychotic symptoms. As those have become clearer, I think the differentiation of what's a personality disorder versus what's a psychotic illness, I think, has become clearer over time.
Can you explain, you spent a lot of time, I think, explaining about the psychosis today, but could you explain a little bit further about the personality disorder that many have observed in Mr. Cayer over time?
Sure. Personality disorders are essentially persistent character styles that create various difficulties, various either occupational or social difficulties for people. And they can be categorized in a number of ways. I think in his case, there has been some question of whether he has some antisocial features, whether he has some schizotypal features, which is just sort of idiosyncratic beliefs and behaviors, whether he has some narcissistic features. I think there hasn't been a clear diagnosis of a personality disorder because I don't think he has one specific personality disorder, but it does appear that he's had some personality challenges over the years.
I think that was your diagnosis as well, right, that it was an unspecified personality disorder?
Exactly. I don't think it fits one category very neatly.
And that's because he has many of those traits that you had mentioned, that he's, he can be antisocial. Some of his belief system is potentially different than other people or than a traditional belief system. So there are a number of different factors that he has to his personality that might contribute to multiple different types of personality disorders.
It's fair.
I think the example Mr. Cotton gave was that, there's somebody who likes to spend a lot of time in the woods and, create strange content in video format. Some of those simply might be consistent with antisocial personalities and not necessarily psychotic.
I agree.
Now, I know there were a number of professionals that evaluated his competency, and I think you certainly did a good job of explaining the difference between a competency evaluation and an NGI evaluation. Those are really sort of two entirely different things, correct?
They are.
Obviously, the existence of a mental health condition is relevant to both, though, correct?
Correct.
But competency really just deals with whether or not someone can stand trial, can understand the proceedings, and can assist in their defense, correct?
Correct.
And it is, as you noted, it is something that is current. So Mr. Cayer's competency to stand trial deals with his current condition in 2020 as we sit here today.
Yes, I agree.
So, and is that possible that can explain some of the changes in terms of the differing opinions regarding Mr. Cayer, is that his competency is different at different points in time?
I think that's possible, although I don't think it's changed terribly much. I think a lot of it is sort of accumulated evidence. It gets clearer over time what kind of struggles he's experiencing.
But you would also acknowledge that while he does display some of the same characteristics traditionally from 2016 to present, his condition has also changed and varied over that course of time as well, has it not?
It has, certainly when we look at those tapes of how he looked in the emergency room, that's different from how he is today.
Correct. In fact, throughout all of the interaction that the mental health professionals had with him, he really did not display that sort of behavior at all in their interactions. Isn't that fair to say?
Well, some of those symptoms, but certainly not to the extreme that was witnessed in those emergency room videos.
And you're obviously aware, based on reviewing the facts in this case, that Mr. Cayer had been involved and is now convicted of having committed a double homicide, having stabbed yet another person. I apologize, some technical difficulties again.
Oh, sorry.
Well, you predicted that this morning. We just need a moment.
We need a moment. We've lost you on the big screen.
Okay.
Yeah. It's on the other side, Mr. Cotton. Top or second one. All right, I think we're back in business. Thank you, everyone, for troubleshooting that problem. Go ahead, Mr. Lassay.
All right, I'll try to regroup again. All right, so you're aware that on June 7th, prior to Mr. Cayer being brought to the hospital, he was involved in a double homicide where he exerted a substantial amount of physical energy in killing 2 people and stabbing another. He was hit in the face with a shovel, and he was tracked by a police dog and bitten prior to being transported by law enforcement to the hospital, correct?
Correct.
Isn't it certainly possible that someone who's experienced that level of exertion and, frankly, trauma that night might also be displaying the effects of that exertion and that trauma when they appear at the hospital?
I think that's very unlikely, but is it within the realm of possibility? Yes.
Do you think it's unlikely that someone who kills 2 people, is hit in the face with a shovel, and is bitten by a police dog is going to display any effects of trauma?
Well, I think they certainly, I thought you meant that he would look like he did. Certainly have some impact from trauma, absolutely.
And for someone with an underlying mental health condition, those factors might exacerbate the mental health condition. Isn't that correct?
Yes.
So while it's fair to say that his state at the hospital when you view him an hour or 2 after the event isn't necessarily identical to his mental state 2 hours earlier before he's initiated any of these events.
It's certainly possible that the events themselves had an impact on his mental state.
What are some of the other factors that would tend to exacerbate a person's mental illness?
Well, stress in general, of any sort, whether it's emotional stress or physical stress, substances of abuse, medical illnesses, I guess those would be the most common.
What about anger that results from stress that's been exerted from outside factors?
Yeah, I guess stress is, that's consistent with stress, yes.
Now, Doctor, we talked about the difference between competency and NGI a little bit, and obviously that competency is present sense and NGI is at the date of the crime, and that's why it's really so important that you've had the opportunity to try to review as much as possible from the time of the event. Is that correct?
Yes.
And in order to do that, you were provided some materials, which you reviewed, including police reports. Did you review all of the police reports in this case?
I can't say I read every word, but I don't know if I was provided all the police reports, but I read the majority of what I was sent.
Are you aware there's over 2,500 pages of reports in this case?
No, and I did not read 2,500 pages.
In addition to the videos that you were provided from the immediate arrival at the hospital, did you also have an opportunity to review the video and audio of Mr. Cayer providing a detailed statement to Sergeant Holzbach and Sergeant Yankee of the Brown County Sheriff's Office?
I guess I'm not sure if there's something separate from what I saw. I guess I don't know that, but what I saw was them asking him questions and him responding.
Now, the videos that were displayed to you this morning, do you believe that's the sum and substance of the videos that were provided to you?
No, I was also sent some written questions and answers.
But in terms of additional audio or video footage, you don't recall having received other additional audio or video footage aside from the same few videos that were shown to you this morning?
No, there was more from the hospital, but in terms of the actual questioning, I think most of that I saw in a written form.
Is that because you weren't provided the audio, or because the written form was easier given the time constraints?
Because I looked at some at the video, but the written form was a little more straightforward and easier to go through.
Well, but isn't it true that if you're really assessing Mr. Cayer's demeanor and his ability to communicate with law enforcement and the way in which he's reacting, that hearing and seeing him would give you a better sense of that than viewing the officer's report?
Yeah, so I did both, but I guess I felt like I saw enough of it, but I did read a lot of it. I found that to be a more efficient way, but I did watch some of it for sure.
Well, isn't it fair to say there's a dramatic change in Mr. Cayer's demeanor from the initial half hour of footage at the hospital to the remaining 8 to 10 hours of his interaction with law enforcement immediately thereafter?
Yes, there is a significant change, I agree.
And I think you attributed that at least in part to the ketamine this morning. Do you believe that all of that is associated with the ketamine?
No, I don't think all of it, but I think the ketamine certainly played a role in helping calm him. But I think some of it was, as you say, there was some stress associated with going through what he went through, and I think his mental health issues crescendoed for reasons that I'm not completely clear.
But it's unclear whether that crescendo occurred prior to him committing the offenses or afterward.
Correct.
Now, in addition to the 9 or 10 hours of audio footage, now some of these questions are going to be rhetorical, but obviously you did not have the opportunity to observe the witnesses testifying in the jury trial about what they observed from Mr. Cayer on the date of the incident, correct?
Correct.
And were you able to review the witness statements and the officers' reports of what Joel Kennedy indicated he observed of Mr. Cayer, as Joel Kennedy was an eyewitness to these attacks?
I did.
And were you able to recall that Joel Kennedy testified that Mr. Cayer had really said next to nothing during this incident? Is that correct?
I did see that he said that.
So Mr. Cayer was not, at least in the terms of the words coming out of his mouth, acting in a way consistent with his actions at the hospital.
Yeah, I don't know about that. I think a lot of his actions at the hospital weren't just his words; it was his demeanor. But it doesn't shock me that he wasn't speaking. I don't know what that says about how he was doing in comparison to what we saw at the hospital.
In terms of Mr. Cayer's preparation for this offense, the fact that he broke into a bedroom window and snuck into the house, the fact that he killed someone in their own home and then lie in wait for the next two individuals, that still shows some organization of thought, some preparation. Does it not?
I think it does.
In addition, were you aware in this case that there were multiple phones found with the batteries taken out of them? One cell phone and 2 home phones with the batteries taken out of them and ripped out of the wall. Again, does that not demonstrate some organization of thought and some preparation?
It does.
Did you have an opportunity to review the body camera footage from the Oneida officer who was involved in the immediate arrest of Mr. Cayer following the incident?
I don't believe so.
If you were to learn that when law enforcement approached Mr. Cayer hiding in the grass, that he responded immediately and appropriately to their questions, would that not be inconsistent with the type of behavior that you observed when he arrived at the hospital?
So I did read that. I didn't see the footage, but I did read what the interaction between them. And but no, clearly it's somewhat different than how he was responding at the hospital.
I mean, his immediate response to those officers was, "I give up." And then he was asked a question, "Where's the knife?" He said, "I don't have the knife. It's in the hospital, or it's inside." Excuse me. Clearly that showed rapid organization of thought when he's responding within a second or two of that officer making that question.
I agree.
So it's quite different than his responses with the hospital staff who are asking him questions about his name and things of that nature. Is that correct?
Clearly there are differences, yes.
Are you aware that Mr. Cayer asked multiple times during the course of the recording, both the recordings that you viewed and the subsequent recordings of Officer Holschbach, that he asked multiple times whether he was being recorded?
Yeah, I saw that.
In fact, he seemed to take a keen interest in whether or not there was any recording taking place.
He asked multiple times, I agree.
And in addition, when he's speaking to Officer Holschbach, he specifically indicated that he wanted to be recorded.
I agree.
Now I know Sergeant Holzbach has a detailed 27-page report, and there's a lot of different things in that report, and it's a very lengthy audio recording as well. And you mentioned some of those things from that recording already this morning, but there were a number of times within the course of that recording where Mr. Cayer is actually expressing remorse for his conduct. Wouldn't you agree?
He is all over the place, but included in his all over the place was some remorse for his conduct, yes.
He said, I fucked up. Correct? He said, I really hope someone isn't dead. Correct?
Correct.
He was concerned that his mother was going to see him on the news. Correct?
Correct.
He specifically said to Officer Holzbach, I did something totally against my belief. It's not fair what I did. Did you observe that?
Did.
Isn't it fair to think that all of those statements are inconsistent with someone who could not appreciate the wrongfulness of his conduct?
No, I think so. It's not clear what he's saying he did. It's not clear when he says I fucked up. It's not clear what he's referring to exactly, because he is just so all over the place about what he thinks he may have done, from getting into an automobile accident to bits and pieces that are somewhat incomprehensible. So it's confusing, honestly, to read through that and to try to understand what exactly he's referring to when he's speaking.
But, Doctor, wouldn't you agree that this is why it's really important to have listened to all those audio tapes all the way through? Because at the outset, Mr. Cayer is clearly expressing that confusion. He comes into the hospital and he's saying, whose car did I steal? What did I do? But slowly over the course of that night, he knows exactly what happened as he's walked these officers through specific details. And if he's making these remorseful statements at the end of the night, after he's made it quite clear what happened, that information is inconsistent with someone who doesn't understand what they've done. Correct? So
I think there were moments in time where it did appear that he knew what he'd done. I agree.
But don't you think under these circumstances, it would have been a lot more valuable to be able to hear that full recording and really have a full and complete understanding of how Mr. Cayer's night unfolded in terms of that confession or statement to law enforcement?
I felt like I got a pretty good sense of it.
If it could be demonstrated that after committing these offenses, he fled from the scene and hid from law enforcement, isn't that in and of itself an understanding of what he did and the wrongfulness of his conduct?
So I'm not sure if that's, I mean, it's, while walking into the grass nearby and sitting there, I don't know. I mean, he seems like he was pretty confused. So he fades in and out of being able to talk about in a rational way about anything, including what had just happened. I don't think that it's clear that he knew that what he'd done was wrong and that he really tried to flee. There's very little that suggests the way he went about this was with a plan to avoid being caught.
But again, that's based on your limited understanding of the facts. You're making an assumption that you didn't believe he could flee, but you don't know all the facts in terms of exactly where he was located, the timing with which he chose to flee after law enforcement is called, and he's aware of that. So all of those things would be factors that one would consider in determining whether someone appreciates what they've just done.
I think that's fair.
Now, when you met with Mr. Cayer and interviewed him, you did have a specific conversation with him about some of the women in his life, correct? You referenced that earlier?
Sort of. There were specific questions. I'm not sure I got specific answers.
That's fair. But there was actually a more detailed portion of the conversation about Sabrina, and I think it's actually outlined on page 3 of your report. There's a good paragraph about Sabrina specifically and a specific interaction that had occurred at his home, correct?
Yes.
And that is what he detailed to you, essentially, that in your report, Mr. Cayer detailed to you that he and his mother had Sabrina and her mother over to their home, and that there was a conversation about a sexual assault allegation.
So it wasn't he and his mother, at least the way he told the story. He was in jail at the time.
Correct. I apologize. That is correct. But that Ms. Teague and her mother went over and spoke with Mr. Cayer's mother, correct?
Yes.
So that is the belief that Mr. Cayer expressed to you in your interview.
Yes.
And that clearly upset him, that he believed that was a false allegation, correct?
Correct.
But that clearly his mother was also upset by that incident, correct?
By his report, yes.
And he indicated that in addition to having that conversation and being upset about it, that he actually had an additional confrontation with Ms. Teague in January where he confronted her on that issue in a Walmart. Is that correct?
Did he freeze?
Looks like it froze.
Usually that only takes a couple seconds, so let's hope he comes right back.
It's Ms. Peters' fault again. Looks like we disconnected.
Sorry, Judge, it's all the technical issues.
It could be the Wi-Fi.
The Wi-Fi isn't great, and I don't think we have the best of computers. All right. Can you hear us, Dr. Robbins?
He's back, but I'm not.
I think I'm muted.
I'm not in now, then. The Wi-Fi kicked us off, so I'm trying to log back in.
They got kicked off the Wi-Fi.
All right. Can you hear me now, Dr. Robbins?
I can. Sorry about that.
No, I don't know if that was on your end. I think the Wi-Fi connection over here isn't working
Mr.
all that well
Eichhoff,
either.
can you fix it so it's not flipping? Thank you so much.
Are we okay?
It's just flipping to whoever speaks, so we just need to change the view. Thank you.
All right. Okay, I was asking you about the conversation that Mr. Cayer had, or not Mr. Cayer, excuse me, that Ms. Teague and her mother had with Mr. Cayer's mother, and then that Mr. Cayer actually had a confrontation at Walmart shortly after that with Ms. Teague, correct?
Correct. When he got out of jail in January, he just happened to run into her in Walmart.
And were you aware that there's also a witness who indicated that a week or two before the homicide that Mr. Cayer also again expressed anger toward Ms. Teague about this very same issue?
No, I wasn't aware of that.
So while some of his thoughts with respect to his girlfriends remain convoluted, it's clear that he's carrying with him some pretty substantial anger toward Ms. Teague regarding what he perceives as a wrongful sexual assault allegation.
Yes.
And were you aware that he actually gave that same motive to law enforcement in the 8-hour-long confession following this crime?
Well, sort of. It didn't seem so straightforward to me when I read it, but he does talk about it.
In fact, he specifically said she's a piece of shit, and that basically re-raised that same issue, that she had made a false allegation against him and that it was not true. Correct?
And he also says that there's more than that, although it's not clear to me what he meant by that, and they didn't ask.
Now, Doctor, we obviously spent a substantial amount of time this morning talking about Mr. Cayer's mental illness history, and I think that's fair. There's obviously a lot of information there regarding his mental illness. But you would agree that not every person that has a mental illness is NGI.
I would agree with that.
In fact, you said in your split, it's probably about 60-40, where you find 60%, 55 to 60% of the folks have NGI, and 45 to 50 40 to 45 do not, correct?
Exactly.
And you're evaluating generally people who it's pretty clear have a mental illness, correct?
Most of the time.
We didn't really spend as much time, anywhere near as much time, talking about the actual elements of this case, which is whether or not Mr. Cayer can appreciate the wrongfulness of his conduct and whether or not he can conform his behavior to the requirements of the law. I'd like to go into those things a little bit more because that's ultimately what the jury has to decide here today, okay?
Okay.
So I guess I would like to know specifically the factors that you considered when you determined that he's unable to appreciate the wrongfulness of his conduct specifically.
Well, it was a combination of the fact that from all the data I read from the police reports, it did not appear that he showed up wearing gloves to avoid fingerprints. It doesn't appear that he did this in a way that he was likely to avoid being caught. He left someone alive. It doesn't appear that he was paying attention in a way that somebody might pay attention who has thoughtfully planned out a murder and doesn't want to get caught. So I guess there's that piece, for starters. Second piece was it doesn't look to me, and I'm happy to listen to what you say, but it didn't appear to me from going through the data that he, exactly had an exit plan that was going to help him avoid getting caught by police. It seemed like a pretty lame and not terribly well thought out plan of what he did after the crime was completed.
But doctor, how is not having a good plan for getting away with a murder equated to not appreciating the wrongfulness of the conduct? I mean, we say that all the time with people who have absolutely no mental illness that don't really care about whether or not they're going to get caught or get away with it. They kill people. People kill people all the time, and that doesn't mean they have a mental illness, correct?
Oh, of course. But he did. But I think it's clear he does have a mental illness, and I think it's clear that his mental illness put him in a condition where he was not thinking terribly rationally at that time, and he did not, in my view, have what appears to be a thoughtful plan to avoid detection, as though he knew this was wrong and he didn't want to get caught because he was doing something wrong, and that he didn't have a great exit plan, which suggested that it adds to the evidence that it wasn't clear to him exactly what he did, let alone whether what he did was wrong. Well,
I think once he understood what he did and pieced it together for law enforcement, it seemed pretty clear that he knew what he did. And I think the latter part of his interview with law enforcement, I think, clearly demonstrated that.
So as is typical of people with mental illness, he comes and goes. And there are times in that interview where he's extremely disorganized and difficult to follow, and it's hard to tell even who he's talking about. And there are other times where he appears more rational. But I don't think there's any question that he had a very serious mental illness, and that's certainly only become clearer over time. And I see little that makes it clear that he understood, other than a couple of brief segments of that interview. In most of that interview, he doesn't appear to have any sense of what he did, let alone whether what he did was wrong.
Well, to be fair, Doctor, I don't know that you listened to the whole interview. There's a heck of a lot of remorse going on in that interview over the latter sections of that, and if you listen to the audio, I think you'd have a better understanding of that. In addition, I mean, the fact that he's angry, that he describes himself as boiling over with rage, people do things in a rage that are not well thought out and well planned, correct?
So that's possible, but it's unclear where that rage is. So when he talked in those interviews with police officers, much like when he talked with me, he goes back and forth between Nicole and Wendy, not just Sabrina. And it's very hard to tell. And he talks about his parents. He's just all over the place, and it's very hard to tell what the rage is about and if that's what led to this criminal conduct.
But certainly it's possible to be rageful at other things that are going on in your life and take it out on someone else. That's happened before in lots of instances, has it not?
That's possible.
Doctor, I want to ask you a couple more questions. Dr. Collins wrote a letter to the court in this case, and you referenced that earlier in your testimony. You had an opportunity to review that letter, correct?
I did.
She was expressing concern about competency, correct?
Correct.
But she actually didn't do a competency evaluation on Mr. Cayer, did she?
She did not.
And in fact, she indicated she was doing an evaluation regarding Mr. Cayer, but it did not appear she was doing an evaluation regarding competency, correct?
It's not clear from that letter, but it's certainly implied.
And you have not seen any other NGI evaluations in this case, correct, other than your own?
I have not.
You offered some opinions earlier regarding a stay in Mendota, and that the average length of a stay in Mendota is typically longer than the average sentence. Certainly you know that's not true with respect to first-degree intentional homicide cases, correct?
I actually think that is true with regard to first-degree intentional homicide cases.
You know what the sentence is for first-degree intentional homicide, do you not?
I'm going to object at this point because...
Life in prison, but it's my understanding that people can get out at some point often. Am I wrong about that?
No, you're not wrong about that. You're aware that he would be eligible for release in 6 months or every 6 months, correct?
From Mendota?
Correct.
Correct. He can apply for conditional release every 6 months. That's right.
And you're absolutely correct that he would not be released unless a court made a determination that it was safe, correct?
Correct.
You referenced earlier that if he receives treatment, that it's possible that Mr. Cayer would gain insight into these crimes that he's committed, correct?
Correct.
But he has received some treatment in this case, certainly regarding competency, and he's been placed on medication. It doesn't appear that has improved his insight into his condition or his crimes at all, correct?
Correct. I don't think he's on the optimal dose at the moment. He's on a medication dose that helps him to achieve competence. I don't believe this is what he...
Doctor, we're not able to hear your response. If you could repeat that.
I'm sorry, I didn't hear that.
Could you repeat your response? You were cutting in and out.
Oh, sorry. So I don't think he's on the optimal medication dose at this time. He's on a medication dose that helped him achieve competency, which was the goal. But I think his medication needs some very serious adjusting if his illness is actually going to go into full remission.
No more questions at this time. Thank you.
Sure.
Thank you. Any redirect?
Let's see if this will work. Okay, do they have to mute? Can you guys mute? Yes, please. Dr. Robbins, am I coming through okay? Can you hear me?
You're muted.
Yes, you're right. Now can you hear me, Dr. Robbins? coming through now? Thank you for your time this afternoon again, sir. I want to talk to you.
We can't hear Dr. Robbins, though. He just responded and there was no sound.
Could you just introduce yourself again?
Kenneth Robbins, Robbins.
Thank you.
Perfect, thank you. I just want to touch on a few points that were made by the state here. First of all, they've talked about this audio clip in addition to the video clip, and you said that you read a report but don't remember listening to an audio clip. Is that what you said?
I don't remember listening to the full audio clip. That's right.
You've listened to parts of the audio clip, just not all 10 hours.
Correct.
Okay. So it's not like you don't have the audio clip. You have it, and you've listened to as many parts of it as you think are important.
Exactly.
Okay. And you've also read a 27-page report from Sergeant Holschbach that analyzes that audio.
Correct.
Okay. With all the different rambling statements that were made over the course of 10 hours.
Correct.
And to be clear, the district attorney's office brought you into the case, not me, right?
That's true.
So when that happens, when a party brings you into the case, it's that party's obligation to give you the materials you need to do your job, right?
Yes, I think that's fair.
Will you expect that that'll happen, and then the other side can provide you with materials if they wish also, right?
Exactly.
Okay. So I want to ask about the crime because you were asked a few questions about the crime, but you talked about the lack of planning, the lack of gloves, the lack of a clear exit strategy. Are those facts the only reason why you're concluding this is a properly supported NGI case? Is it because he didn't have a good exit plan and didn't wear gloves?
No.
Is there a lot more to it than that?
Yeah, absolutely. It's his mental state. It's his mental state that has really persisted for 4 years.
And
it's difficult thinking in an organized fashion. It's his difficulty providing any explanation for this crime. It's his paranoid delusions. It's his grandiosity. It's primarily about his mental illness, his psychotic symptoms, including thought disorganization, that have persisted.
And you said, when Mr. Lassay asked you about this, you said that it's helpful to have a long period of time to examine a person, starting with the incident going forward, because it gives you a clearer picture. Is that your testimony?
Yes, that is my testimony.
So when you diagnosed Mr. Cayer with schizophrenia, and you say that there's psychotic problems here, that's based on the full spectrum of materials that you've examined throughout the case.
It's fair. I mean, if I was Dr. Lee and I had seen him a month after this happened, I probably wouldn't be diagnosing schizophrenia.
Got it. And especially because he was committed twice to a mental hospital and treated with antipsychotics, that's very important information to know.
It is, both the fact that he, in a mental hospital, he can be observed by professionals 24 hours a day and they can track data, and that he responded to the treatment for psychotic disorders with some improvement, though not certainly full improvement.
Right, he's nowhere near optimal in your professional opinion.
That's correct.
And the condition you're identifying today, you're not saying that he just has this condition today. Your conclusion is that this condition existed at the time he committed the offense.
Correct, and I think it would be very unusual if it started suddenly on that day. I think there's good reason to think it was building and crescendoed on that day, and it has persisted now for 4 years,
And that's
despite treatment.
And that, at the end of the day, is exactly what mental health is, isn't it?
Is observing over time and trying to adjust to the data over time. Is that what you're saying?
Yes.
Yes.
And unfortunately, with somebody who has this, is schizophrenia a fairly significant mental illness?
very significant mental illness.
Because there's different types throughout the DSM of mental illnesses, right?
Correct. There's many. There can be an anxiety disorder, a mood disorder, a personality disorder, a substance use disorder, but certainly, in general, the disorders that are most disabling, that are most severe, are the psychotic disorders.
And I think, sir, doesn't that tie into the vicious nature of the crime, too?
I think it likely does. I think
Sir, you need to wait for a response. There's an objection. Thank you.
It's a leading question. There's been a lot of leading questions. I frankly also think it's beyond the scope of cross-examination.
Sustained.
On cross-examination, you mentioned that Mr. Cayer is, quote, all over the place. What were you referring to with that?
during that interview, his thinking is very disorganized, and he jumps from talking about one person to another, and it's often very difficult to tell who exactly he's referring to. So, for example, when we talk about his being rageful, it's very unclear what he's talking about exactly. What is he rageful about? Who is he angry at? It's never really very clear.
And you were asked about Mr. Cayer hiding from the police, and you commented that going into the grass and laying there or sitting there doesn't seem like much hiding. You remember that?
I do.
So one of the things you look at is the level of planning that goes into a crime, as well as the things that happen in the immediate aftermath of the crime. Those are both things you consider?
Yes, that along with the mental illness itself. Exactly.
Okay. And then the state asked some questions about mental illness and how lots of people have mental illness but don't meet the NGI standard. You would agree with that. There are lots of mentally ill people who do not meet the standard of NGI.
That's right. There are mentally ill people who commit crimes, and it's not NGI at all. They clearly understood what they were doing.
And you don't have any issue or problem reaching that conclusion when that's an appropriate conclusion?
If that's what I believe to be the case, and it often is, then I don't have any problem reaching that conclusion.
The state asked you about whether there's other NGI reports you've reviewed. There's no other contrary report other than you. Isn't that fair to say?
Not that I'm aware of.
That's all.
Any recross?
No, Your Honor.
All right. Thank you, Mr. Robbins. You can disconnect from the Zoom call. Any additional witnesses you'd like to present, Mr. Cotton?
No, Your Honor. We'll move our exhibits into evidence.
All right, and those exhibits are?
Exhibit 20.
I received that one earlier, yes.
20 through 26.
I don't know that they were all identified. I'll have to check with the clerk. And 20, 21, and 25 were the only ones that the clerk and I have note of. And I believe I received 20 and 21 already, and then 25 was the thumb drive with the video clips.
Yeah. And then 22 was the Elliott Lee report.
It wasn't shown to the witness and identified.
He identified it as a report that he relied on, Your Honor.
It wasn't used as an exhibit. Do we need to address this outside the presence of the jury?
Sure.
All right, ladies and gentlemen, we need to take a brief moment to address some legal arguments. I'll make it a 15-minute break so that you have time to get outside or use the restroom or whatever. So if you could come back at 3:40, you're reminded once again not to discuss the case or do any research. Please stand for the jury. be seated. So, Mr. have testimony about things, but there were things that weren't used as exhibits, so I don't know how to admit those. And I think the jury can clearly rely on the testimony that they heard, but there wasn't any identification of exhibit 22, 23, or 24. And I'll double check my notes, but that's what the clerk had as well. So 20 was Dr. Robbins' CV, 21 was his report, and then 25 was the thumb drive.
Right. 22 is the Dr. Lee competency report.
It may be that you had it marked that way, but you didn't show it to the witness and have him identify it. So it wasn't used with the witness.
Well, it was used because that's true, I didn't show it to him, but we referenced it, and he did identify it as a report that he read and relied on for purposes of his conclusion.
And the jury has that in what they heard. But
Right.
what is your position, Mr. Lissay? I mean, I don't admit exhibits that haven't been identified by witnesses and haven't been shown to witnesses typically, so.
I don't think it should be accepted as an exhibit or just because it wasn't shown to anyone and identified as that. And frankly, I mean, I don't see how prejudices the defense case to not have it. It's in the court record.
Well, and what I mean is they heard testimony about it, so I don't think it prejudices the defense in any way, but I don't know why I would admit an exhibit that hasn't been identified by number or as an exhibit. So,
well, the jury may ask for it. That's why.
Well, they're not going to get it because it wasn't admitted it wasn't identified as an exhibit. They wouldn't even know what exhibit to ask for. Yeah. So if you want to move Exhibit 25 in, we can talk about that. That is the thumb drive. It was presented to us. Mr. Cotton, I believe it was, or Mr. Eichhoff, I don't recall who, handed me the thumb drive. I gave it to the clerk. And that's Exhibit 25. Any objection to that being received? All right, so when the jury comes in, we'll tell them Exhibit 25 is received. All right, did you want to make any further record on Exhibits 22, 23, and 24?
And 26, which is Dr. Engen's report. I think they're all admissible because they're documents that the doctor relied on. So I think that it's fair, even if they weren't presented to him, to be admitted. They're also documents that are prepared in the official course of business, and I don't think there's any question about their authenticity or reliability, Judge.
Well, they haven't been used in the course of the trial. They've not been identified as exhibits. I guess if you want to offer something that wasn't identified by this witness, that's a different issue if you're trying to get some other report in, but nothing in the way of Exhibit 22, 23, 24, 26 was identified by the witness.
Okay, I'd ask to recall Dr. Robbins for purposes of identifying those exhibits then.
And that's fine if you want to make that motion, but I'm going to also tell you that chances are those will not be going to the jury even if they ask for them. Typically that's not the kind of thing that goes to a jury. But if you want to, do you have a position on recalling Dr. Robbins? Okay, and that's fine if you want to do that and have them identify those exhibits. You can do that.
You want to do it that way, or do you just stipulate that come in?
For the record, yes, I think we have to do that. We don't just admit exhibits that haven't been identified in a trial.
Well, by stipulation, the parties can admit exhibits, though. We've done that throughout the case with these videos, for example.
You're right, Judge, it is. But you can stipulate that certain items go into exhibits. So you could create that little stipulation. If it comes to it, I'm going to strongly object that those things go to the jury. I don't see any reason why that material would go to the jury.
I think that's probably true, that there's a much different question if it goes to the jury. I agree
All right,
with
so
that.
if you want to identify for the record what all these exhibits are, because you had them marked prior, I think yourself maybe, the clerk doesn't even have a list of what those are. They've certainly not been identified, but if you want to do that, go ahead right now.
We pre-marked them, Your Honor, and they've been forwarded to your clerk, so they'll be in her email. Exhibit 22 is Dr. Elliot Lee's report. 23 is Dr. Deborah Collins' July 10th letter.
Letter?
It's a letter, yes.
And what date was Dr. Lee's report?
That was July 11th, 2016.
Okay.
24 is Dr. Landis's report,
Dated?
November 1st, 2019.
All right, thank you.
25, of course, is the USB drive. 26 is the Dr. Engen, Christina Engen report,
Could you spell the last name, please?
Engen,
And the date of that report?
is September 20th, 2019.
All right. Any objection to those exhibits being received by stipulation so that Dr. Robbins doesn't have to be recalled to identify them?
For efficiency purposes, we'll stipulate that those two are designated at 10%.
All right. And I'll receive 22, 23, 24, 25, 26. I already received 21 and 20 earlier. All right. Is the state going to be calling witnesses?
The state has 6 more clips.
Okay, can you turn your microphone on?
The state has 6 more audio clips that I think it's 6
Okay.
more audio clips that we'd like to play.
Well, as long as we have a few minutes, can we talk about the jury instructions then, so that we can accomplish that? Now, I just took some of these from the state submission and some from just standard civil instructions. So if you want other instructions, you'll need to ask for them or let me know so that I can include them. But you received the packet that I put together and gave to you yesterday, is that correct? As well as the potential proposed verdict form?
Yes.
Okay. First, let's start with the verdict form. Any objection to the proposed verdict? I labeled it a special verdict and took questions 1 and 2 straight from the jury instructions.
I have no problem with that.
That looks fine, Aaron.
And I just clarified that that is consistent with jury instruction 603. Yes, go ahead.
So this is a question I kicked around with my team earlier in the week, and I think I know the answer, and I think I'm comfortable with us just doing this once. But do we have to do it for every count, or do we just do it for the entirety of the trial? I mean, I think on the facts of this particular case, it's probably one question and answer, practically speaking, but are we required to have them consider it for every count?
I did not think so because of the structure of the trial, but that does raise an interesting point because they are determining responsibility
Yeah. I mean, conceivably,
for
certain...
each count, technically.
Correct.
Mr. Cotton?
I think it's fine the way you have it. I think it's appropriate to ask the question. I don't see how you could. I think it's fine the way you've written it.
So you don't believe that you could find, that you could answer question 2 differently for the various counts?
No.
Like I said, I think under the facts and the circumstances of this case, it's most likely that they would find all or nothing. But I don't know the answer. Legally, are they required to find that on each count or not? I don't want to do something incorrect. I don't want to later come back if let's say they don't find him NGI, and then we have to come back and say, well, the jury was supposed to have made that determination for each count.
How would we structure it? You would structure...
You'd say you'd have a verdict for every count, just like you did previously.
I'm fine doing it that way if that's what you want. It doesn't matter.
I
think it's probably better. I think it may be better.
It's safer that way.
I don't think we could be wrong doing it that way.
Correct. I'm worried we could be wrong doing it this way. I don't think we could be wrong doing it the other way.
So would you propose that just question 2 would be altered to say as to count 1, as to count 2, or what would you be proposing?
I would say we give the same verdict for all 6. Obviously, I would assume that the answer to count question 1 would be the same for all of them. But I would propose we just submit 6 of these verdict forms and say as to count 1, please answer these questions. As to count 2, please answer these questions.
So we, the jury, as in for a verdict, find as follows: as to count 1, and then as
First degree
just
intentional
change it just
homicide,
there.
Yes.
Mr. Cotton,
I think that's fine.
you let me pull one up and see what that looks like. Do you think we need to list what each count is then? I think we do.
I do
As to
too.
count 1, first degree intentional homicide of Sabrina O.T.
Right, so there's no confusion.
You and I had to fight over that.
Well, that would kind of suck, to have the hospital say you're okay, and then you would have worse.
Freaking out. Something's wrong. All right, so the issue is whether or not we have to have some kind of a colloquy with Mr. Cayer about whether he wants to testify or not. He made it extremely painfully clear this morning he didn't want to appear at or participate in the proceedings, but he wasn't asked exactly whether he wanted to testify or not. State v. Legrone is the case I was looking at, and I also looked at State v. Murdoch, and Legrone says, although a better practice, a circuit court is not required to conduct a right to testify colloquy at the responsibility phase of a bifurcated trial resulting from a plea of not guilty by reason of mental disease or defect. So they're saying you don't have to do it, but it's probably a good idea.
Based on my research, Your Honor, I would agree with that case law.
We should still ask.
Of course, I didn't know that this would be an issue before today. I would have looked at this sooner had I known, but that's the case law that I came up with here this morning as I've been looking at this issue.
And it was reaffirmed in a 2019 case, State v. Fugere. And so I believe that it would be sufficient for counsel to reach out to Mr. Cayer, confirm whether he would like to testify or not. Depending on his response, we could arrange for him to testify if he chooses to do so. If not, based on his representation of his.
I'm going to do a colloquy with him regardless. If we're going to take the effort to get him on the phone and verify that with you, then I'm going to do the full colloquy with him. So I will have. Are you already calling the jail? Okay, while the clerk is making that call, did you look at the verdict form as revised with respect to count 1? You want me to do that with each count now? Or do you have some other request?
Okay. It's my request that the court do this with each of the 6 counts.
We're fine with that.
And then we're going to have to do Zoom after that. Well, they're going to have to.
Your Honor, is it okay if I, off the record?
Yes, you can step out. I mean, we're in the middle of a homicide trial, and they're going to have to do what we need.
Yeah, we have Wi-Fi, so we can
Okay.
stuff in the hallway if we need it.
Okay. I don't know if that hallway is the best, but over here, we'll figure it out, and then we can just connect, hopefully, and do the hearing right away. If we set up a Zoom hearing, hopefully keep them for both. That's what we'll try.
If we can just let the jail know that.
4292. And
The jail just package was in a way that I want to talk to him, I think it would be.
It makes sure the jail knows that Mr. Eichhoff, can they tell him that Mr. Eichhoff wants to talk to him?
they may not even have any tablets, he said.
Well, I will get them one.
So it's Attorney